Hello, this is David Olshan of Nevada Legal Services. This is another in our series of substantive videos regarding your legal defenses when you're faced with eviction. We are going to go through the eviction defenses according to the eviction notice. So with a 7-day pay rent or quit notice, you do have 3 general areas of a legal defense. One is that you paid the rent or tried to pay the rent. And when I cite to that statute 40.253, that's where that legal defense lies, paying the rent or trying to pay the rent. If you have an offset, which means you have money that the landlord owes you and you subtract it from the rent, if the money the landlord owes you equals or exceeds the rent, whether it's under Chapter 118A, the lease, or other applicable law, that would provide a defense. That's contained in 118A.490, NRS 118A.490. Also under Nevada law, under 118A.355, you can withhold the rent if you give the landlord notice of a habitability problem and the landlord fails to fix it within 14 days, you can withhold the rent and you do have a defense if the landlord tries to evict you with a 7-day pay rent or quit. Also, insufficient notice is a legal defense. We will talk about those in a later slide, but insufficient service of an eviction notice does provide a defense. For a 30-day no-cause notice, your defenses are your lease is not expired, 40.251(1)B. This is retaliation or discrimination by the landlord, 118A.510. If you complain about a problem and the landlord evicts you instead of fixing the problem, that's retaliation. If you complain about discrimination, the landlord has steered you to a part of the complex for certain races or ethnicities, that's discrimination, and if the landlord tries to evict you, that does provide a defense. Also, insufficient notice is a defense to a no-cause notice. If you get a 3-day nuisance notice or a 5-day lease violation notice, the defenses are pretty much the same. They are, I didn't do it, I did do it, but it's not a lease violation or a nuisance, or the nuisance or the lease violation is minor and it has stopped. You also have insufficient notice as a defense to a 3-day nuisance or a 5-day lease violation notice. So what is a nuisance? How is it defined under Nevada law? There's 2 statutes that deal with it, NRS 40.2514 and NRS 40.140. Basically, it's when your conduct seriously affects other tenants or the landlord, or is dangerous or illegal. So if anything like that is happening, perhaps you're having a wild party and it's 2 a.m., that would be a nuisance. Excessive foot traffic is a nuisance. Garbage that accumulates inside your apartment, that's a nuisance. It's serious behavior. It's serious behavior that affects other tenants, the property, it causes property damage, or it affects the landlord, that's a nuisance. When you're talking about an insufficient notice defense, you're going to go to 40.280 and look at the requirements for service of an eviction notice. It must be done by a registered process server, constable or sheriff, or an attorney or an agent of the attorney. Also, the notice must be served on you personally or on someone of suitable age and discretion and mailed, or posted and mailed. So if this is not the type of service, perhaps it's just taped to your door, that's insufficient notice. If the landlord serves you an eviction notice, that's insufficient notice. Violating this law, 40.280, would provide a defense because insufficient notice does affect subject matter jurisdiction and the court would not be able to issue an eviction order. If you file an affidavit and get a hearing, what happens at the hearing? Well, first of all, if you want to know what happens at the hearing, go early, sit in the audience and watch some of these summary eviction hearings. Usually they take less than 5 minutes. When you do represent yourself, you should get to the point as quickly as possible. Bring in any proof that you have, whether it's in the form of a witness, a piece of paper that's a rent receipt, a ledger, a letter to the landlord. Those are all going to be helpful if you go to a summary eviction hearing. But keep in mind, you have to talk to the judge or the hearing master and not the landlord. So if the landlord says something that's false, don't argue with the landlord. Tell the judge, yes, I paid the rent and here's my receipt. That's how this should work. It should be quick and speedy. And again, it takes less than 5 minutes. The legal standard the judge or the hearing master will be looking for is whether it's a summary judgment standard, whether if there's no genuine dispute as to any material fact, and you are entitled to judgment as a matter of law. So that's the Supreme Court case where we get this standard. Keep in mind that summary judgment sometimes can involve witnesses and testimony, but the summary eviction is designed to be quick and speedy. So again, the landlord is saying you owe rent. You're saying you don't owe rent and you provide a receipt. That would be a defense. There's no genuine issue as to any material fact. You have supplied proof of the rent and you are entitled to judgment as a matter of law. The landlord can't evict you. This is the Justice Court rule that deals with summary evictions and the process. Again, no formal pleadings are required. It's supposed to be a quick hearing where fair and speedy justice is dispensed. When you go to a summary eviction hearing, act quickly, get to the point, and tell your story, because this is the only time that you will be able to do that, to make a record in front of the judge. We are Nevada Legal Services. If you're in Las Vegas or Southern Nevada, dial 866-432-0404. In Reno or Northern Nevada, dial 800-323-8666. We provide free legal assistance. We defend people in summary eviction hearings every day. So if you want assistance with an eviction, please give us a call.